Mr. President.
The senator from Arizona.
Mr. President, I come before the Senate today to talk about this Waters of the U.S. rule and the legislation pending before us, S. 1140. I hope that we can proceed to the bill. This is an important issue. Obviously, the definition of waters of the U.S. sets the rules of the game of who is covered under the Clean Water Act. As has been stated, several Supreme Court decisions over the past decade or the decade and a half have created some uncertainty, a lot of uncertainty for landowners and those who work the land, who aren't sure whether they are going to be regulated or not. Regulated entities need a rule that is consistent and that has some predictability. That is not what we're getting here with this rule. The rule issued on June 29th defines jurisdiction very broadly, as we've heard, especially when it comes to streams that don't flow year-round, intermittent and ephemeral streams, of which Arizona has many. Now, several scientists who have been involved in the rulemaking process have told my staff that there is a disagreement between what the science says and what this rule says. Science says that some streams are strongly connected and others are not. There's a so-called spectrum of connectivity, but this rule assumes that they are all strongly connected. Let me just show one picture of a stream here. This is Dan Bell, a rancher in southern Arizona near the border of Santa Cruz County, standing on a stream bed or a dry wash or a roro that will likely be covered under this rule. Now, like Dan, I grew up on a ranch in northern Arizona. I've ridden through my whole life, 7-mile draw, 9-mile wash. The topography of the land was named for some of these dry washes, but they only had water after a good rain and lasted a few minutes. That was it. Those will likely, under this definition, under this new rule, be defined as waters of the U.S. Now, if you can imagine what ranchers and other agricultural users are feeling right now, thinking that the federal government is going to step in on top of other state regulation that already occurs in regulating what goes on with these stream beds or these dry washes. On August 27th, a federal district court judge blocked the implementation in 13 states, including Arizona, saying, quote, "It appears likely that the EPA has violated its congressional grant of authority in its promulgation of the rule at issue." As we know, on October 9th, the Sixth Circuit Court of Appeals stayed the rule nationwide. Now, there is not a consensus, obviously, on what this rule does or does not do. In internal memos, the Army Corps of Engineer Assistant Chief Counsel of Environmental and Regulatory Programs highlighted a number of, quote, "serious areas of concern" with the rule, including the, quote, "assertion of jurisdiction over every stream bed," which would have, quote, "the effect of asserting Clean Water Act jurisdiction over many thousands of miles of dry washes and auroros in the desert Southwest." So when you hear people stand up and say it's not going to affect dry washes, that's not what the rule says. We need clarification here. We need to pass the legislation today. We need to actually invoke cloture so that we can debate it and ultimately pass it. This is a bipartisan measure that will address this issue and provide ultimately, with a new rule, the consistency and uniformity that those who work the land really need, and we will benefit from in Arizona, and the entire country will benefit from. With that, Mr. President, I yield back.